This is something that I've talked about many times so far. I know people are really interested in this, obviously, as you should be. I guess the main thing, though, that I want you to take away from this is that, so the theory of this law, the theory of the law that restricts employer conduct is that, listen, so marijuana's legal now, right? And so maybe you won't be so strict with your employees. Maybe you'll rein in your policies a little bit. That's kind of what the theory was. But I can tell you that in practice, the way the law was actually written and enacted, that is not the case. So employers have lots of discretion and lots of disciplinary power to deal with employees who you think may be high at work. Employees are not allowed to be high at work, right? So that can be your first rule. So that has not changed. So the first thing that I want to do is really focus on what the law is now. Because if we understand what this law that restricts employer conduct, it goes into effect next summer, July 1st, 2022. The employer parts of the law go into effect next summer. So, and they're not crazy different from what they are now, but I think it really helps to figure out what the law is now so that then we can comply with it now. And then also we'll compare what's it like now and what will it be next year, next summer. And so the laws that we're going to talk about that are in effect now are, we've got this act concerning the responsible and equitable regulation of adult use cannabis. That's the legalization of marijuana law. And so this is, right now, what is in effect is that adults 21 and older can have 1.5 ounces on their person, and they can have 5 ounces in a locked container in their car or at home. And then the part that restricts employers' conduct, that's the part that takes effect next summer. Then we have PUMA, and that's Connecticut's palliative use of marijuana law. And so that has to do with people that are holding a medical marijuana card. And those rules are slightly different than the rules for employees who don't hold that card. We've got the Connecticut Fair Employment Practices Act, and the reason why that is sometimes relevant is because you cannot discriminate against people with disabilities, and you have to sometimes accommodate those employees with disabilities, and sometimes the use of marijuana will help people with their disabilities. All right. So we're talking about drugs and alcohol in the workplace, and the things that you can do right now is you can prohibit the use of intoxicating substances during work hours. And notice I said intoxicating substances, right? So you don't want your policy to be that you prohibit the use of illegal drugs, because of course you do, but you also prohibit the use of legal drugs at work. You prohibit the use of alcohol, and you prohibit the use of legal marijuana. You can discipline employees for being under the influence, and you can require drug testing in 3 situations. All right, so if it's part of an application procedure, or if you have reasonable suspicion that someone's under the influence at work, or, So if you refer, keep following along with your packet, because it looks like sometimes the bottom of the slides aren't showing up. The third time that you can do testing is if you're the type of employer that can do random drug testing. All right, so when we talk about drug testing in Connecticut, so there are laws, there's a whole set of statutes that regulate your ability to do drug testing, and it only applies to urinalysis. So if you want to do a breathalyzer for someone who you think has been drinking, or you want to do a hair analysis or a blood test, the state of Connecticut won't regulate that. The only thing that the state regulates is urinalysis. And so if you're going to do urinalysis testing, No decisions on promotion or compensation or anything like that can be done unless you do it twice. That's if the first one comes up positive. So if you've got a positive urinalysis test on an employee, you have to do it again. And then if you get 2 positives, then you can take action. And so when we talk about pre-employment testing, we're obviously talking about applicants, right? And so the applicant has to be informed in writing that you're going to do this. And then if it's positive, they have to be given a copy of the positive result. And the person can't have started work when you do this test. And so what that means is, so when they're doing the application process and they're filling out the forms, you let them know that you're going to be doing drug testing, right? And so what you do not want to do is have them then come in, you've decided to take them on, you say congratulations, you have them fill out their W-2, and you do your health insurance forms, and you do some onboarding, and then you say, okay, now we're going to go do your drug test. It's too late now. It's too late for that drug test because the person's now your employee. And there's different rules for employees. So if you want to do your pre-employment drug testing, it's got to be before you make that offer. It's like a conditional offer. If you pass the drug test, then you will become our employee, and then we'll start onboarding you. Yes? Yes, if you say in so the question had to do with an offer letter. So yeah, you can say in your offer letter, we'd love to have you come aboard, congratulations, these will be the terms, but you'll have to pass the drug test that we told you about already as part of the application process.
But that's in the offer letter. Do we still have to do it at the application process?
Yes, you have to do it, if it's in the offer letter, that's only because you already mentioned it at the application process. When they are first applying, they need to know that this is something that they're going to have to do. You're welcome. All right, and so the second type of, yes?
I'm sorry, you were just talking about the second confirmation test.
Yeah.
On it. I just want to make sure I understand that. There's such a thing as there's a split specimen test where the original collected specimen is basically stored separately, and they can run the test on the first one. Could you run that second test on the original collected specimen?
So the question has to do with split specimen tests, and my understanding is that that is not considered 2 tests, that there has to be 2 donations. Okay. All right, so the second type of testing is reasonable suspicion testing, and this is for current employees. And so you have to have reasonable suspicion that the employee is right now currently under the influence of drugs and alcohol. But you want to test them because you think they're under the influence right now. And it's got to be that that is impacting their ability to do their job. Now keep in mind, I'm not talking about disciplining employees, I'm talking about drug testing them, and they're different. You don't have to drug test your employees unless you do. Unless you're employing like school bus drivers or CDL drivers, and then you do. But if you're not a mandated tester, you don't have to give drug tests. And so think of it as kind of like a search and seizure when you see that on TV and you have certain rights. And drug testing is considered to be an invasion of privacy. You're giving your bodily fluids. And so the standard for asking someone to do a drug test is higher than the standard for just disciplining them, okay? And so let's say you've got an employee on the shop floor and his job is to sweep the floor, and you think that he's under the influence of drugs or alcohol. Let's say he's high. Of course you can have a rule against that. You can't be high, and you can discipline that employee for being high. But if that does not affect his ability to sweep the shop floor, you cannot drug test him, because drug testing is the ability to drug test is more strict than the ability to just discipline him, okay? And this applies to current employees and former employees who worked with you in the last year that you're rehiring. So when we're talking about reasonable suspicion, what gives you reasonable suspicion to think that someone might be under the influence? The Labor Department has not come up with anything set in stone. There isn't anything in the law that is officially considered a reasonable suspicion, but they've kind of over the years come up with a unofficial list, and none of it will be surprising to you. You know, it's like smelling alcohol on someone's breath, or smelling marijuana on someone's clothes or hair, watery eyes, dilated pupils, making mistakes, or acting in a really different way than the employee typically would. Someone called me recently about an employee who kept falling asleep in his truck. So falling asleep in your truck alone probably wouldn't be enough. But falling asleep in the truck and then also a smell of alcohol on breath, that's definitely enough. That's reasonable suspicion. Interestingly, possession of drugs is not reasonable suspicion to drug test. So again, possession of drugs, let's say you discover that one of your employees has drugs on him. That's a disciplinary offense for sure, but it's not reasonable suspicion to drug test them because you don't necessarily know that they're under the influence of drugs. They're just holding the drugs on them. So you can fire them if you want, or you could discipline them in some other way, but it's not enough to drug test them. So one thing that's come up with this reasonable suspicion issue with current employees is sometimes maybe you're the employer and you have a client and you need to send your employee to that client, and the client wants your employee to be drug tested. So what do you do then? You cannot drug test that current employee, right? You don't have any reason to believe that they're under the influence, so you can't, as a condition of employment, require that employee to be drug tested, even though the client that you want to send him to requires drug testing. There are a couple of options, though. One is obviously not to send that particular employee to that client. The other is to see if the employee will sign a waiver that says they're very willing to do this drug test, they have no problem, they understand that it's to go work for this client, and they also understand that it is not required. If it's not required to keep their job, the employee signs the waiver and says, okay, yep, I'm perfectly fine doing that drug test, and then I'll go to that client. The other way to kind of get around that is if the client does the drug test rather than you, because the client is not the employer. But that's can be a little bit tricky. There'll be some liability then for the client in other ways, and that wouldn't be my first choice. Let's just put it that way. So the third type of drug testing.
Just a question on the last slide.
Yeah.
So you talked before about the reasonable suspicion.
Yep.
For testing, but if it's not affecting their job performance, then that's not enough to have reasonable suspicion unless there's other conditions that exist.
Yep.
So if the employee's performing well, or you suspect something, whether it be alcohol in his breath or someone saw him using marijuana during the day, I guess that would be enough under reasonable suspicion.
To drug test him?
Yes.
You're saying, so you're asking, is it enough to drug test someone if you, what did you say, you smell alcohol?
Well, if they're still performing their job, but there's other suspicions that you see or hear about, I got the sense before that unless it's affecting their job performance, it's difficult to have them get drug tested.
Right, so if you smell alcohol on their breath, or if another employee tells you that they saw them smoking marijuana at work, that is enough, that is reasonable suspicion to believe that they're using drugs at work, and that's a disciplinary offense, presumably. But if it's not affecting their work, then no, then you're not drug testing them, okay? And really, I just want to emphasize, remember, you don't have to drug test. Sometimes drug testing is more trouble than it's worth. If you have reasonable suspicion to think people are using drugs, that's enough. Did you have a question?
I just had a quick follow-up on that. You had said a couple slides ago that the law applied to urinalysis only. Would a workaround for some of these things be to use like the oral swab?
Yes. Yes. So if you want to drug test someone and you want to do a hair analysis or a swab, like you said, that would be a workaround because Connecticut law doesn't cover that. You know, theoretically, if you were to do that, maybe the employee would object, and there would potentially be he would maybe file a claim against you for some sort of invasion of privacy, but that's very blurry and vague and not common. So, yeah, that's a potential solution. And so for the random testing, this is permissible if it's authorized by, it says federal law, it actually should say state and federal law. And like we mentioned earlier, there are state laws that require testing, like for CDL drivers and school bus drivers. It's also, random testing is also allowed if the employee works in a high risk or safety sensitive position, or if the test is conducted as part of a voluntary EAP. And so let's talk about just those high risk and safety sensitive positions. Those positions, though, that's not something that you decide as the employer. So if you think that you employ someone who is in a high risk position, you write to the Labor Department, the Connecticut Labor Department, you describe the position, and you ask them to please designate it as high risk. And then the Labor Department will investigate. They'll ask you lots of questions. They may even come see what the person does. And then they'll issue you a decision. Yes, this position is high risk and safety sensitive. It's not high risk until the Labor Department says it is. And you might notice if you go to the Labor Department website that there's a list of safety sensitive positions. That doesn't really apply to all of you necessarily. That's just, those are people that have been designated high risk in the past for particular employers. And so, for example, like if you look on that list, you'll see one of the high risk positions is painter. All right, so if you're a house painter, that's not necessarily high risk, but if you paint bridges on highways, that's pretty high risk, right? And so it really is individualized. It depends on the individual case-by-case scenario. So you write to the Labor Department, and they write back telling you if it's high risk or not. And then we talked about the fact, when I said there were 3 situations when you could do that random testing, I didn't mention the mandated, like the CDL drivers and the school bus drivers. And so just generally speaking, when you're trying to figure out if you employ high-risk employees, people in high-risk positions, we're talking about an occupation that has clearly significant life-threatening danger involved, okay? And it has to require the exercise of discretion on the part of that employee. It's got to be dangerous, and he's got to have his own discretion on how to do this job. That'll kind of give you a sense of whether the Labor Department is going to give you that designation. All right, so that's drug testing. Let's talk a little bit about, and this is all current, this is what the law is right now. Let's talk about medical marijuana. So this is PUMA. And this law provides employment protection to employees who are qualifying patients. And again, that's not something that you all decide, but just so you know, to be a qualifying patient, you've got to be a Connecticut resident, have a debilitating medical condition, be 18, or have permission of a guardian. You have to register with the Connecticut Department of Consumer Protection, and you have to have written certification from a physician or APRN. All right, so if you have all those things, you're a person who holds a medical marijuana card, all right? And if you are a person who holds a medical marijuana card, you have a little more protection than people who don't hold that card. And mostly that comes up in the application process. So if you are hiring someone, if you're considering whether to take someone on, and that person does your pre-employment drug testing and the test comes back positive, but they hold a medical marijuana card, that cannot be the reason that you don't hire them. And really, practically, the way it's supposed to work in the state of Connecticut is the lab who does the testing if they get a positive result and they are able to confirm that the applicant holds a card, the lab is supposed to reverse that result and say that it came up negative. And so the employer never even finds out that it was positive in the first place. So, but if that doesn't work out, if there was a glitch in that system and you find out that it was positive but they hold a card, you can deny employment to that applicant for some other reason. You just can't deny employment because they have that card. So you can't the idea is as an employer, you can't think to yourself, oh man, that guy holds a medical marijuana card, that's gonna be a pain in the neck, right? That's not okay. Yeah.
How does it apply to federal law, or federal contractors and FAA rules?
So medical marijuana is not legal under federal law, right? And so federal law trumps state law. And so that's kind of like a whole nother issue that you have to deal with there. Yeah.
So we have workers who work on railroads, and right of way on railroads means that they need to be in random pools. And that happened after we hired them. The railroads all came out and said, if you're on railway, you need to be in this random pool drug test. So if some of those people hold a medical marijuana card,
Yeah.
and that's their job,
Yep.
to work doing inspection on a railroad.
Mm-hmm. I'll be honest with you, I'm going to have to think about that one. I'll give that some thought during the break and see. Yeah.
But the pool, we're in a pool with like 4 other companies. It's not
Yeah.
a big group of people. If one of them just says, well, I have to go get tested, but by the way, here's
Yeah. Right. Right. Okay. So I will think about that. All right, so while you can't make a hiring decision based on someone holding a card, you can obviously still make a disciplinary decision based on their use of their medical marijuana. A person with that card can possess the marijuana at work. They can have their card, they can be a card holder, but they can't use it at work, okay? So you can discipline a person with a medical marijuana card if they're using their medical marijuana at work. So let's move on. So that's medical marijuana. So we're still talking about what the law is now, and let's talk a little bit about smoking, just regular smoking. This was part of the law that legalized marijuana, actually, and I think it came as a surprise to many people. This went into effect on October 1st. And so this law says that employers must prohibit smoking of any kind, period. Doesn't matter how big you are, doesn't matter how many employees you have, how big your facility is, there's no smoking. So this applies to the interior of your facility, and it also applies to the area 25 feet from your door, window, or vents. So all of us who have that awning outside the front door where everyone smokes, you have to push everyone 25 feet, okay? Now, one thing that has come up a fair amount is the signs. Some of you have heard that you need a sign. And I can tell you from experience, the sign is big, right? I know that because we tried to print them at CBIA and we could not. It's really big. And so one thing to just keep in mind, if you look at your materials, the person who has the responsibility to post the sign is the person who's in control of the premises. And that might not be you, might be the landlord, right? And so, but whoever is the person in control of the premises has to post a sign that says no smoking under Connecticut law. And the letters have to be 4 inches high. And the stroke of the letter has to be 1/2 inch wide. And that's big. Okay? So that's something to kind of look into. Yes?
What if you're in a building and you have subtenants, lease, you have subtenants, what do you do about an infraction? I mean, like, I don't think there's people driving
Right.
In the state of Connecticut, and ready to it's to an infraction on smoking. So how do you handle that?
How does who handle it? The
Landlord or
so the landlord would
of the subtenant?
so the landlord would technically get the infraction for the tenant. Well, so the landlord would get the infraction for not posting the sign if the landlord is in charge of the premises. You're right, though. I don't know who's going to be driving around issuing these infractions, right? But in theory, you would get an infraction for not posting that sign. And then? Where does the sign need to be posted? We don't know. So the question is, where are we posting the signs? So all the statute says is that you don't have to post it in every room. That's good. But you have to post it in an area where people are walking around, where they'll see this sign. Okay? So, maybe in the lobby, but I'm kind of making that up because the statute doesn't really say. It just says in the premises that you have control over, you're going to post this sign. Okay? All right. Let's talk about the actual legalization of marijuana. So as I mentioned kind of at the start, the theory behind this law that restricts employer conduct is that, marijuana is legal, so we're going to try not to punish our employees too often for using marijuana. And so we understand some of you should maybe be exempt from that requirement. Again, that's just kind of like the theory behind it. So there are 9 exemptions. And you can see they all kind of have something in common. We're mostly talking about safety-sensitive positions, companies that employ these safety-sensitive positions. So mining, utilities, construction, manufacturing. Also people that work with children, so people in the education field. National security, international affairs. So these 9 exemptions are based on NAICS codes, which I'm sure a lot of you are familiar with. A NAICS code is not something that is bestowed upon you. A NAICS code is something that you decide. And so if you haven't already, you can go to NAICS.com. It's NAICS.com. And you figure out your NAICS code. So if you go online, there's categories and then subcategories and then sub-subcategories until finally you get to the employees that you employ, and you'll see mining. And so you'll say, okay, hooray, I'm exempt, I'm mining. And so something to keep in mind is that if your company is exempt because your company is in mining, everybody in that company is exempt. And so let's say you're a manufacturer. Not only are your manufacturing employees exempt, so is the bookkeeper and the CFO and the HR manager. Everybody employed by that exempt employer is exempt. Okay? The other thing that the statute does is it talks about exempt employees. And I just want to, before I talk about this, I want to make sure everyone understands. Usually when I'm talking about exempt employees, I'm talking about people who don't get overtime and who get a certain salary and who do certain duties. That is not what we're talking about here. It's kind of a shame that the statute uses this word. That's not the type of exemptions we're talking about now. So when we're talking about marijuana, if we say an employee is exempt from this marijuana law, what we mean really is that the employer is exempt from having to follow the new law as it applies to restricting its ability to punish this employee. Okay? And so that sounds kind of confusing, but again, the idea is really the same. We're looking at safety-sensitive positions that are exempt. And so let's say, for example, I work for CBIA. CBIA is not exempt. But theoretically, maybe CBIA would like to employ, maybe they want to have an EMT on staff all the time. The EMT is exempt. And so the way in which the employer handles the way that EMT smokes pot, that EMT is exempt from the new law, okay? Because in theory, the new law is restricting your ability to discipline these employees. All right, so these are all the 13 exemptions that you can see in your materials. And then finally, this is what we've all been waiting for, the next 2 slides in your materials talk about the way in which the new law actually impacts employer conduct. And so what I've done is I've separated it out, the next 2 slides. The first slide is what you can do, and the slide after that is what you cannot do. Okay? Beginning next year, beginning next summer. So there are 4 things you can do. And guess what? You can also do them right now. It's not new. All right, but what's kind of interesting is that this law that goes into effect next summer, it specifically lists these. It specifically says to the employers, these are the things you can do. All right, so you can enforce rules requiring a drug and alcohol-free workplace. Great, yep, you're already doing that. You can prohibit employees from possessing, using, and consuming cannabis while working. Great, you can do that now. The one exception is the employee with a medical marijuana card. They can have it on them. You can implement a policy that prohibits possession and use of cannabis. Yep, doing that now. You can do that again next year. And you can discipline employees based on, okay, look at your materials, the employer's reasonable suspicion of cannabis use at work, or the employee's symptoms of drug impairment. And so again, that's not drug testing, that's disciplining people, right? Those are the 4 things that you can do and still follow the law that goes into effect next summer. Now, when we were talking about reasonable suspicion earlier, and I said that the Labor Department had come up with some things that they thought were reasonable suspicion, but they weren't actually part of any law. The new law that goes into effect next summer, it actually does specify things that may be that you could consider to be reasonable suspicion, that you could consider to be evidence of drug use at work. And they're mostly the same. It's just interesting that they're actually listed in the statute, and those are things like slurred speech and dilated pupils and unusual behavior, carelessness, accidents at work, disrupting manufacturing processes, things like that. And so those are now things that are actually in the statute that you can use for your basis to discipline someone based on their use of cannabis at work. All right, and we are at the point where we're going to talk about what you cannot do. And it's interesting, see, so I've been trying to kind of give you the impression, don't worry, this new law, it's not that different, and it's not going to restrict your conduct very much. And look what we have. We've got 3 things. And the 3rd one you can't do anyway. You already couldn't do that. So starting next summer, these are the things that you cannot do. So you cannot discharge or discipline an employee based on their use of marijuana outside of work, unless you have a policy that says you can do that. That's kind of the interesting thing. And so you'll see how important it is to have a policy. So if you want to be the type of employer that you have a 0 tolerance policy, you will not be hiring people that smoke marijuana. And you don't care if they do it outside of work or inside of work. Your policy is that it's not going to happen. That is permissible if that policy is in writing. I don't know that you'll have to think about whether you actually want to do that, but it's permissible under the law. If you don't have a policy, you can't do that. And so if you don't have a policy that specifically allows for it, then you're supposed to let your employees use legal alcohol and marijuana on the weekends outside of work, okay? The second thing you can't do, even if you do have a policy that allows it, So the second thing is you cannot discharge, discipline, or adversely treat a current or prospective employee based on his history of using marijuana outside of work before he even started working for you. And so you may say, well, how is that even going to come up? This actually did come up for a client of mine years ago. And so the way that comes up is you've got an applicant and you're thinking about hiring, and so you do a Google search and you kind of look the guy up a little bit and you say, oh, look at those Facebook posts from a couple years ago. He was smoking marijuana. And so now, today, you could say, I don't know how anyone would even find this out, that this was your decision, but you could say to yourself, yeah, I don't want to deal with that. I'm not going to hire that guy. Starting next summer, that cannot be the basis to not hire someone. The fact that you knew that someday in the past he smoked marijuana, okay? You can do that, though. There's that one exception, if you have a federal contract.
So I just have a question. I know that marijuana stays in your system a lot longer than, say, alcohol.
Yeah.
Positive, like if we have a new employee starting and we drug test them and they test positive. Currently, we wouldn't hire that person. So
Right.
How does that impact?
Yeah, so the question about pre-employment testing, that's something that you'll have to think about, because you're right, with the urinalysis testing in particular, THC stays in your system for 30 to 60 days. And so if you do pre-employment testing and it comes up positive, all you know is that that applicant maybe used marijuana a couple of months ago. And is that instructive? Maybe it is. Maybe you make helicopters, and that's instructive. But maybe that's not a policy that you want to have anymore. Maybe you don't want to screen for that anymore. Maybe you don't want to maybe you don't care about pre-employment testing. These are all the things that you have to think about. So the third thing that we are not allowed to do next year is, this is not new, this has to do with drug testing. You can't penalize a current or prospective employee based on a drug test that's positive solely for THC. And remember, it just says that because this is the THC law, right? So if it's positive just for THC, you can't penalize that person unless you have one of these 4 scenarios in your packet. And they're the same as what we already talked about. You either have a federal contract or you reasonably suspect cannabis use at work. You see symptoms of cannabis use at work, or you're a company that does random drug testing. So if you meet one of those typical scenarios and you do a drug test, then you can discipline the employee. The way that this would come up is if you drug tested an employee and you really didn't have a reasonable basis to drug test them, or maybe you made an applicant do a drug test and you didn't let them know that that was a requirement. So that will be a violation of this statute. Again, nothing really new. One thing that I just put in this packet, just something to kind of think about, a couple things. So remember, the intent, in theory, the intent of the new law was to discourage punishment for these positive THC results. And in fact, it doesn't really do that, right? So the result is still the same, the middle point there. If you have a positive test result, and the reason why you gave them the test in the first place was because you had reasonable suspicion that they were using drugs at work, you can discipline them. One thing that I was just going to point out is that the law, this new law, does say that you can drug test someone if you have a policy that provides for random drug testing. And that's a little confusing because currently you can't just have a policy that provides for random drug testing. You have to be statutorily allowed to do random drug testing. And so I know that the Labor Department, I've spoken to people at the Labor Department, and they're not really happy with the way this came out, and I think it probably was not the intent. Technically, the way the law is written now, you could come up with a policy that says we're going to do random drug testing. and that would be allowed. I don't recommend that you do that because I don't think that was intended. And the Labor Department doesn't think that that's the way it was intended. And it may be that that actually gets changed. But just so you know, if someone brings that up in some way, technically there's a suggestion that you can come up with a policy that provides for random testing. And so what's going to happen to you if you violate this law? So you're going to get sued, in theory. So these are things that the Labor Department will not investigate. There are certain things that the Labor Department gets involved with, and then there are certain things that they don't. They're not going to get involved with this. And so it goes right to court instead. So an employee or an applicant has 90 days from the day that you do whatever you did to them. They've got 90 days to file a lawsuit. And if they win, they can get reinstatement and back pay and their attorney's fees. And so we're talking about someone like if you didn't hire someone because of a drug test and you didn't give them the adequate notice, then they could sue you, and then they could get that job, and then they get all the wages that they should have gotten in the whole time it took to get through that case, and they could get their attorney's fees as well. So the statute actually specifies two situations where a lawsuit will not be valid. And that's what I mean when I say no cause of action. That's the way the statute writes it. So there's no cause of action, which means no valid lawsuit, where the employer had a good faith belief that the employee used or possessed recreational cannabis at work or was unfit for duty. So after all this that we've been talking about, if you can show, I had a good faith belief that he was doing this, that he couldn't do his job, that it wasn't safe, that he was high, then that lawsuit won't succeed. And then they kind of throw this in here, which I think was meant to make you relieved, but I think instead it's going to cause some anxiety because you probably never even thought of this in the first place. But the statute specifically says that if one of your high employees hurts somebody else, goes out, gets in a car, hurts someone, don't worry, you're not liable if you had no reason to know that that employee was high. Don't worry, right? And so for a lot of people, they're like, wait, what? I was supposed to even be thinking about that in the first place? But if you had no reason to think that that employee was high, you're not responsible for whatever that employee does to somebody else when he hurts that person. By the way, that is kind of like a topic for a whole nother seminar, right? When are you going to be responsible for when your employee hurts someone else? But don't worry if they're high and you had no reason to know. It's not going to be then.
Even on the job.
Who's?
They're on the job and they drive somewhere.
Yeah.
You didn't know they were impaired.
That's right. That's right.
Not with our.
How they leave for work.
See, I knew this was going to create all these questions.
You can't apply to all situations, like if it happens on the weekend or something.
That's right. Of course not. Of course not.
That's related to work.
Yes. Yeah, so the question was if the employee who is high and hurts someone else on a weekend, you're not responsible then, and of course not. You are not responsible then. All right, so we talked about this a little bit already when we're talking about best practices. The first thing, hopefully, is something you've already been doing. Remind your employees that just because marijuana is legal to use and possess outside of work, it doesn't mean that it is legal to or allowed to possess it and use it at work. Did I say that right? Just because it's legal outside of work doesn't mean it's okay at work. You should update your employment policies, right? And we talked about this earlier. A lot of policies prohibit the use of illegal drugs. So you want to go a little bit beyond that. You want to prohibit the use of intoxicating substances. I don't think the question had to do with CBD. I don't think that is enough. I don't think that qualifies. And so this is the most important part. You want to just sit and think. the question that came up in the back earlier, what do you actually want your policy to be? You can either be a zero tolerance employer, that's fine, you could do that. Maybe you don't want a zero tolerance policy though for something that's legal, particularly outside of work. Maybe you don't want to do pre-employment testing. And I'm not advising either way. This is just something for you to think about. I know that some of you have said to me that you don't do this pre-employment testing anymore because you're trying to get employees and you're going to weed out, right, all these applicants who may test positive. And again, like I said, if they're testing positive, this is for something that they may have done weeks ago. So it's not really even instructive for you when you're trying to decide whether to hire them. Yeah. Yeah.
You can still run the other drug tests. What about, like, if you have CDL drivers? So if you have specific, you can eliminate it for everyone except, like, the CDL driver or someone who isn't exempted?
Yeah, so the question had to do with limiting what you screen for different types of employees. So, right, let's say you have a CDL driver. You're going to test, you have to test for marijuana for a CDL driver. But if you're testing for your bookkeeper, yeah, maybe that's not a great example. Let's use the floor sweeper again. You could test, you can have your drug testing company test for opioids without testing for THC. So you can kind of decide what you care about. What test result is the test result that's actually going to impact whether you hire this person or not? What test result is the test result you actually care about? And so as we talked about, the marijuana that stays in your system for 60 to 30 days. And that actually, before I end, that just raises one thing having to do with unemployment, which I didn't touch on, but just so you know, that the fact that marijuana stays in your system for 30 to 60 days impacts whether the issue of terminating someone and whether that person is eligible for unemployment. So let's say you drug test someone and it's positive and you fire them, but you didn't have any basis to think that they were actually high at work. The person is still going to get unemployment. It's okay that they were fired, but they're still going to get unemployment because it may have been in their system for so long. The Labor Department will say, yeah, well, but you don't really know that they were high at work. And so, just something to be aware of. That'll affect unemployment. So, yes.
So, in a previous page, you had said that if we implement a policy that prohibits the possession and use of recreational cannabis, that it must be in writing and given to the prospective employee prior to their offer.
Right?
So are we allowed to, at what point, and do we have the right to ask if they have a medical marijuana card? Or no, is that protected by HIPAA?
It wouldn't be protected by HIPAA. HIPAA doesn't apply to employers, okay? But when you're in the application process, that's right, you would not want to ask if someone has a medical marijuana card, just like you wouldn't want to ask if they had a disability, because the fact that they have that card should be irrelevant to you.
Right, but let's say we have this policy and they have a card, are they required to tell us? If, let's say, so I work for a restaurant group, so,
Yep.
we have multiple locations, and if, for example, a manager saw someone walking and a bag of marijuana fell out of their pocket, they're not supposed to have it at work. So now we're going to discipline them. It is a terminable offense right now, but then are they then required to say, I have a medical marijuana card to protect them, or should they be telling us that prior to?
I think that, so did everyone hear that? So Okay, so you have someone walk by and the marijuana falls out of their pocket, and that's not allowed. So I think the way that would go is that then the employee would say, but wait, no, I actually am allowed to have it. I have a medical marijuana card. But there wouldn't be any responsibility for the employee to disclose that ahead of time. It would just be something that they would explain to their employer as to why they have marijuana on them.
So as long as we have our policy in place and they're aware of that policy prior to their offer,
Right.
even if they don't share that information with me and it falls out of their pocket, they have no obligation to tell me after seeing our policy.
Right, because so let's say you have a policy that says you can't have marijuana unless you have a card, right? That would be your policy. And then the applicant who becomes an employee reads that and he says, yep, check, okay, yep, I got a card, so I'll be okay. And then they go to work and it falls out of their pocket and they say, no, see, I have my card, right? So I don't think, it's really it'll be more of a managerial training issue, I think. So you would want to let your managers know that this is a thing and that, hey, if someone ever gets caught with marijuana, if they tell you they have a card, look at the card, make sure they have a Department of Consumer Protection card. And if they do, then they're allowed to possess it. But if they're behaving strangely and you think they might be high, that's a whole nother issue.
So I thought you could have a policy in place that said that even though you have a medical marijuana card, you're not to possess the drug on property.
So if you have you can have a policy that prohibits the possession and use of marijuana, but there's an exception to that. You can't prohibit a card holder from having its medicine, in a sense, right? So you can't prohibit a card holder from having their marijuana on them. You can prohibit them from using it.
So if we remove THC from our drug screening, if later on, say, we think that there's reasonable suspicion while they're working under an intoxicating substance and it's THC, is that a disciplinary? Can we do something with that if we've removed it from our drug panel?
Sure. Yeah, because remember, there's no obligation to drug test.
Okay.
Right? So if you're removing it from your panel, you mean like at the application stage?
Yes.
Yeah, so let's say you don't test for it anymore at the application stage. You're not testing for THC, you're just testing for other things. But then later, you have reasonable suspicion. You could either discipline them because you had reasonable suspicion that they're high, or you could then add that screen in for THC and you could drug test them.
Okay.
Yeah.
And I know you said that, this is going to initiate its own training course, but
Yeah, oh no. Yeah.
if someone's high at work and I don't notice that you're, look intoxicated or under a substance, let's say, but maybe I don't see you when you first get to work. And let's say you slip and fall or you hurt yourself at work and then we realize that you are high. Mm-hmm. Does that fall under our responsibility with workman's comp because you got hurt at work?
Yes, that'll be a workers' comp issue.
Even though you were high?
So that'll be the commissioner's decision to make, right? If he or she says, well, I mean, I don't even know how, I don't know how, we'd have to try to play that out. So then you would maybe drug test them right away, right after they fell, so that you can establish.
I was told by our attorney, obviously prior to this law happening, that if we suspect somebody's under the influence and we want to drug test them right there, we actually have to call our attorney to come down to the location.
The attorney?
Yes, and be on site because there's a lot of background to it.
Yeah, I've never known that to happen.
To be there
Yeah.
in person when it's happening.
Yeah, I don't know. Has anyone
we've
ever
never
had that
had
where
to
their
do it,
attorney
but-
actually comes down and watches the drug test? That would be expensive. Yeah. Yeah.
Just on the exempt employers, I know you touched on
Yep.
it slightly, but
Yep.
it says utilities, construction, manufacturing. Is that determined by somebody else, or if you fall within a utility company, are you automatically exempt from the marijuana law?
Yeah, so you would go to NAICS.com, you'd look at the code. Let's say you think you're utilities.
SIC code or something?
Yeah.
Okay.
Yeah. So if you think you're utilities, you'd go to the website, and there are lots of different kinds of utilities. You see if you fall into one of those, and if you, as the employer, say that you are utilities, then you are.
And then if you're exempt, then
And
you
then
don't
you're
have
exempt,
to follow the marijuana laws.
And then you can ignore everything that I said.
I go home now.
Yeah. Yep. Hold on one second. I just want to make sure that if anyone hasn't asked a question. Okay, go ahead.
Just a quick thing on letting people know in advance about the pre-employment drug testing.
Yeah.
If it's in our policy, obviously, if we're in the application process, they're not seeing that.
Right.
Can we put it in our job postings and on our application? Is that enough to notify employees?
You could, but I think if you just put, I would do both. You could put it on your posting that a drug test is going to be required, but you'd still want to give them in writing a piece of paper that says a drug test is going to be part of the application process.
Because that's tough when people apply online and then you're,
Yeah,
especially if they just send a resume and say from Indeed.
Yeah, so if your people are applying online, you would have to have some sort of disclosure online that they can read. They really are supposed to sign it also. So that kind of raises an issue that I don't know the answer to.
Put it in your application,
Yes,
apply, and then
yep,
having them fill out the application is what they do before almost anything else.
yeah,
Put there,
you could. You could put it so, yeah, right,
for the reasonable suspicion testing, my understanding is that you can have just another person who's also trained on recognizing what reasonable suspicious testing should be. It shouldn't have to be the lawyer. You could do reasonable suspicion training at your facility, and then you'd have two managers who could go over and say, yeah, he's definitely high, versus the lawyer having to come in and
yeah.
say, yeah.
The thing
yeah.
with the lawyer, I've never, that's news to me, I don't know.
Pretty good gig for the lawyer then, yeah.
Yeah, I don't. Okay. So yeah, I don't know about the lawyer. The question having to do with who decides if it's reasonable suspicion. So yeah, training your managers is obviously a really good idea. So you have your managers go through, talk to your managers about the checklist, like the glassy eyes and the slurred speech and all these things. And you don't have to have a designated person who's a specialist on reasonable suspicion. But if you have managers that are trained in that, that'd be the person that you bring in to give an opinion.
Can I ask a follow-up question about the reason? You just said that there was no specific requirement in the law about what that looks like, because in the regulated DOT space, there are specific rules about how reasonable suspicion is determined, and I think you were just referring to it a moment ago with the two managers. That's what it describes in the federal law. So there's nothing like that in this law that it requires that two-manager view or that ongoing training for managers, because that's in the federal law.
Yeah, no, the state law just, it gives examples of things an employer might consider to be reasonable suspicion. There's no specific requirement that a certain number of people make that designation or anything like that. The lobbyists at CBIA tell me that this is almost like a rough draft of this statute, and that we can expect maybe some changes in the next session. And so there are some things in the law that may be tweaked. There are things that don't completely make sense, to be honest with you. So it may be that this goes through some revisions this next session, and that it becomes a little more clear in that sense. And so let's do one more, and then we'll take a break.
I'm just curious, you mentioned for the medical card, having a Connecticut medical marijuana card. What about a Massachusetts medical marijuana card?
Yeah, so the person that needs protection in Connecticut is the person who registers with the Department of Consumer Protection in Connecticut. And so I guess my advice there would be if you have an employee with a Massachusetts medical marijuana card, if you can verify that that is a legitimate medical marijuana card, it would probably make sense to apply the same rules. It's just that Connecticut law, it's just kind of the way the laws work. The Connecticut statute only applies to its own residents with its own cards. But it would make sense, logically, to just recognize cards from other states if you can verify them.